Would you like to work at the CNMI or the Commonwealth of the Northern Mariana Islands? If yes, then watch this video till the end because I want to tell you about the US CW-1 visa. Hi, this is Max from the Visa Library. Many of you contacted us and requested a video for the US CW-1 visa. In this video, I will describe the necessary conditions to obtain this visa, the requirements, how to apply for it, and so much more. If you haven't subscribed to our channel, no time is better than right now. Do it so you can stay updated every time we make videos about new visas and to get a cheat sheet for this visa at the end of the video. Well, let's go. What is the CW visa? Employers at the CNMI can use this non-immigrant visa, CW1 visa, to hire foreign workers who do not match other categories of US work visas. CW is a temporary work permit. Annually, 12,999 workers can enter the United States under this visa. This visa has two categories, CW1, that is for transitional workers in CNMI, and CW2, that is defined for dependents of transitional workers. The dependents who are eligible to apply for a CW2 visa include a spouse and children under the age of 18. What are the eligibility conditions of CW1 visas? First, let's talk about the employers. Number one, the employer's job must be legal, real, active, and operational to produce services and goods. A business will not be considered lawful if it involves prostitution, human trafficking, or any other activity that is banned under the federal or CNMI law. Number two, before applying for this visa, the employer must evaluate all available workers in the United States. Number three, CNMI employers must offer hiring terms that are compatible with their business type. Number four, the required force to employ transitional workers must be registered. 5. The employer must fulfill all labor laws such as occupational safety, minimum wage, and non-discrimination. Number 6. If necessary, the transportation cost of workers to the last place of residence must be paid by the employer. Number 7. The employer must comply with the semi-annual reporting requirement by the timely filling form I-129CWR. Number 8. Employers must obtain an approved temporary labor certification or TLC from the U.S. Department of Labor or DOL and consider all available U.S. workers for the position. Now, let's talk about the requirements of workers with the CW1 visa. Number 1, the terms of these workers must not be in accordance with the terms defined in other employment visas. Number 2, workers are recruited to provide the resident workforce. So, they have to stay in the CNMI and work in the specified job class. Number 3, a legal employer who has a business in the CNMI must apply on behalf of the workers. Number 4, the worker is only allowed to be in the CNMI. Now, how to apply for the US CW visa? The application process for a CW1 visa is divided into two categories according to the place of residence of the worker. First, the workers who legally live and work in the CNMI with a federal status such as an F1 visa or H1B visa. If the employers intend to hire one or more than one workers who have parole authority granted by the USCIS or CBP, they must submit a form I-129CW. The employer must submit the form I-129CW along with additional documents indicating that the provided information about the worker, employer, and the job position is correct and meets the required standards. In the second step, the fingerprint and photograph of the worker are taken to be conducted for the necessary security checks. If Form I-129CW is approved, USCIS will send an approval notification to the employer who must provide a copy of the documents. This document will demonstrate whether you have been conferred CW1 status in the CNMI or whether you may move to a US embassy abroad to inquire about visa processing for the CW1 visa. Now, second step. A foreign worker who lives abroad and seeks employment in the CNMI. The employer must submit the Form I-129CW along with additional documents indicating that the provided information about the worker, employer, and the job position is correct and meets required standards. If Form I-129CW is approved, USCIS will send an approval notification to the employer. The employer must send the original approval notification to the worker's address abroad. In the third step, the worker will need to schedule an appointment for a non-immigrant visa interview at the nearest US embassy. If you get CW1 status and your dependents want to join you, then they might file Form I-539 concurrently with you. While dependents may wait until the CW1 request is issued, they should be legally present at the time of filing their appeal to be qualified for the CW status in the CNMI. It means the dependents may need to register the Form I-539 before the I-129CW is given to preserve accountability for CW2 status. CW2 status does not allow employment. Dependents must also pay the application fee for filling and the biometric services and the documents of the admission to the CNMI in the CW1 classification. Now, how much does it cost to issue the CW visa? The employer must pay $200 as a CNMI education funding fee per beneficiary. The biometric services fee is $85, which is funded by the worker or employer. Another question, how long can you stay with the CW visa? The length of a stay under the CW1 visa is 1 year. To lawfully stay in the CNMI, the worker must re-register for the CW status. Another question, can CW visa holders change their employer or employment? As long as the legal process is followed, you can change your employer. Unlawful change of employment to a new employer will result in the loss of the validity of CW1 status. The prospective employer must register a petition of a new CW1 status for the worker, as well as an extension for the validity period of the new appeal. To extend the status of the CW visa, the employer must submit Form I-129CW. Even if you do not change your employer, any changes in the conditions of the employment are a reason to file a new petition to maintain the validity of the CW1 status. Foreign workers who have CW non-immigrant status will lose if they break any of the terms which are defined in the CW status. However, if the violation is only made by termination from employment, the worker will not be regarded to have violated the status if the worker finds a new job in 30 days from the date of termination and an employer registers a petition on behalf of the worker. If a new job is found, the new employer must submit a request before the end of these 30 days to maintain legal residence in CNMI. After petitioning the file by the new employer, the foreign worker can begin working. If a petition is filed after 30 days, the request must first be approved. Then a CW-1 visa must be issued at a consulate outside of the CNMI. After that, the worker can return to the CNMI and start a new job. Here's another question. Can workers travel outside of CNMI? An approved I-12-9 CW petition means having the CW status. If you travel outside of the CNMI, you will need to apply for a CW visa to re-enter the CNMI and preserve the CW status. Well, there you go. Now you can start your application and get that sweet US CW1 visa. If the steps were so confusing, don't worry. I've put a cheat sheet on our website. Go ahead and download it. Link in the description. Don't forget to like the video and subscribe to our channel. It will help YouTube's algorithm. If you have any type of visa that you want to know about, write the name in the description and we will make a video for it. Thank you all for watching.